Welcome to your last lesson in this plant propagation course. As a propagator, you need to know and understand your rights and responsibilities. The reference on this slide to the Intellectual Property Office New Zealand, or IPONZ, is highly recommended as it covers all the legal details you will need as a propagator or plant breeder. To get you thinking about rights and responsibilities, we have put together a few summaries in the following slides that will outline the forms of protection available and the rights of plant breeders and licensed growers. What is a plant variety right, or PVR? A grant of plant variety rights for a new plant variety gives you the exclusive right to produce for sale and sell propagating material of the variety. In the case of vegetatively propagated fruit, ornamental and vegetable varieties, plant variety rights give you the additional exclusive commercial right to propagate the protected variety for the commercial production of fruit, flowers or other products of that variety. Plant variety rights, or PVRs, are a way of protecting plant breeders' intellectual property. There are a number of reasons and benefits of applying for and owning PVR. A PVR will give you exclusive rights to produce for sale and sell propagating material of the variety you have bred, the ability to collect royalties from licensed growers of your protected varieties, the ability to prevent or claim damages from a company or individual that deliberately sells seeds, propagating material or plants of the protected variety without your permission or under another name, an asset that you can sell, license, mortgage, or assign the rights to another person or business. How do you know if your plant meets the PVR criteria? To apply and receive a PVR for a specific plant, there are three main criteria that must be met. 1. The plant must be a new variety that has not previously been offered for sale. There are some prior sale rules, so make sure you check these out on the IPONZ website if you are thinking of applying for a PVR. 2. The plant must be distinct, uniform and stable. Distinct means different in its colour, shape or have a desirable characteristic not previously known to exist, such as a resistance to a disease. Uniform means that all the plants look or behave the same way. Stable means all the plants propagated will stay the same as the original description, no matter how many times they are propagated. 3. Your plant must have an acceptable name. This means the name chosen must be accepted by an international panel. How do we know if a plant has a PVR? A good place to start is to check the label. The next would be to check the PVR register. And it should be noted that plant variety rights can last for 20 to 23 years. So far we have discussed the protection of new plants and propagating material by using PVRs, or plant variety rights. This protection can only be applied to plants and plant material, but there is often other intellectual property that a horticulturalist needs to protect. In the next few slides we are going to look at trademarks, copyright and patents. A trademark is a unique identifier, often referred to as a brand or logo. Once a trademark is registered, the R symbol may be used with the trademark. Trademarks can include words, logos, colours, shapes, sounds, smells, or any combination of these. Trademarks are not used on your new plant. This has already been protected by a PVR. However, you may wish to use a trademark to brand your plants or plant products to assist with marketing. Have a look at this label. Note the small r in the circle identifying a registered trademark. In this case, it is the name Silver Ghost. This plant does not have a PVR, and so the trademark helps identify this plant in the marketplace. Rules around trademarks. The trademark you choose must comply with the Trademarks Act 2002. It must be distinctive. That is, something that people will remember, as it will identify your product from others and make it stand out. We can recognise trademarks by this symbol, a capital R inside a circle, or a capital TM. Trademarks protect your business. The next form of protection you can use is copyright. The term copyright refers to a bundle of exclusive rights given to owners of original works like prototype drawings, films, and sound recordings. In New Zealand, copyright is an automatic, unregistered right that comes into existence every time an original work is created, published, and performed. The work must be original and fall into one of the following groups: literary works, dramatic works, musical works, artistic works, sound recordings, films, communication works, and typographical arrangements of published editions. The person who produces the original work usually owns it and can sell, copy, perform, or communicate their original work to the public. There are two cases where you do not own the original, and that is when you create the original in employment. Your work belongs to your employer as they have paid you to do it. And the second is when you are commissioned to create an original work. The person paying will then own the creation. On this label, you can see examples of plant variety right, trademark, patent, and of course copyright. The artwork on this label is original and therefore has automatic copyright. Here is another example. Look at the writing on this label. It is original and therefore is covered by copyright. The next form of protection is a patent. A patent is a right that is granted for an invention. You can patent a new product or process, the material it is made from, or how something is made. Owning a patent gives you the exclusive right to commercially exploit an invention for up to 20 years. During this time, you can take legal action to prevent others from using the invention without your permission. A patent gives protection for an invention within a country or region. A New Zealand patent gives protection within New Zealand. You must apply for protection if you want it in other countries or regions. Do not share the details of your invention with others until you have lodged your application, or it may be turned down. Here is an example of a patent that has been applied to a plant label. Other examples may be horticultural tools, machinery, or processes. Remember, an invention must be new, inventive, and useful to be protected by a patent. New means it has not been described or displayed before. It must have an inventive stage or step that is not already known, and it must be industrially applicable.